Thank you, Mr. Presiding Arbitrator. The claimant will respond to each of the respondents' rather dramatic submissions on the question of jurisdiction, and shall, we hope, more calmly show that the tribunal does indeed have the power to examine contracts despite allegations, here spurious allegations of bribery. The respondent has based its passionate argument on the decision of Judge Lagergren in ICC 1110/1963. However, it has failed to acknowledge the development of the law since that decision. In fact, a number of subsequent decisions, both of courts and arbitral tribunals, have, yes, referred to Judge Lagergren's decision there, but they have not followed it. Just one of many examples is the Westacre v. Yugo import dispute, where courts in the United Kingdom, Switzerland, and Kuwait all held the arbitration agreement to be enforceable despite corruption surrounding the main contract. The basis of these rulings is none other than the doctrine of separability, which we all know, which treats the arbitration agreement as a separate agreement from the main contract in which it's contained, and does not allow the invalidity of the main agreement to extend to the arbitration agreement. Perhaps the most authoritative pronouncement on this point remains the UK House of Lords decision in Fiona Trust versus Privalov, where it was held that corruption could not invalidate the arbitration agreement unless the agreement was directly impeached by the corrupt act in question. Gentlemen, this is an exacting test. Unless the allegation of illegality relates to the arbitration clause itself, the tribunal can proceed to decide the dispute. And the dispute on the merits, of course, would include any allegations of bribery. Further to this, the claimant argues that the facts in the record do not reveal any clear evidence of the claimant's complicity in the alleged corrupt practices. It's trite law that the agent's power to affect the legal position of its principal depends on its actual or apparent authority. So let's look at those in turn. Actual authority requires consensual agreement between principal and agent endorsing a certain act. None of the evidence adduced by the respondent shows that the claimant requested the middleman to act in this manner, or even suggested that such an act was acceptable. In fact, the claimant was wholly unaware of its agent's actions until after those actions were reported by the media. Turning to implied authority, neither can it be said that the claimant provided the middleman with implied authority, which extends only to acts that are ordinarily incidental to the due performance of an express authority. Bribing a minister in a government can hardly be considered ordinarily incidental to the agent's function, at least not by the claimant. Perhaps the respondent has different views. The key fact of the matter, gentlemen, remains that the claimant was selected for this power plant contract from among several other companies. The claimant was selected on a meritorious basis, considering its expertise and its industry-leading track record, of which you have read in the record. To close, I want to urge the tribunal to pay particular heed to the fact that the respondent, having known about the middleman's alleged transgression, did not once raise any objection, any alarm, any outrage, until when? Until the commencement of this arbitration by my client, the claimant. This concludes our submissions. Thank you for your patient hearing.
Thanks to both counsel. We particularly appreciate the efforts made by both of you to keep the time limits and to make relevant and cogent arguments. Both of you have made powerful submissions, which we will have to consider carefully. We will now retire for our deliberations.